Everyone, hi. I would like to welcome you on behalf of Bristol Law Society today for our webinar. Today we'll be exploring some of the trending topics in planning and environmental law, and I am delighted to be joined by Brendon, Moorhouse and Harry Spurr, who are both barristers at Guildhall Chambers. Before I hand over to them to kick us off, I'd just like to remind you that this session is being recorded and will be available after the session on our YouTube channel along with our other webinars. We will also be taking a Q&A at the end of the talk, so please put any questions you have in the Q&A function. We will be monitoring the Q&A function for questions, so please put your questions in the Q&A function rather than the chat. We will also be circulating the slides materials after this recording, so you don't need to be scribbling down notes. You can focus on what we are saying, and we will be emailing that after this presentation. That was all I had to say. Just thank you again on behalf of BLS for joining us, and I will hand over to Harry to kick us off. Thank you.
Thank you very much, Coralie, and good afternoon to you all. It's a pleasure to be here today and to have the opportunity to talk to you. Thank you for joining us. Thanks to Coralie and Claire and your colleagues for inviting us. Brendon and I are going to talk to you about some emerging themes in planning and environmental law, some current issues. And the way I thought I would describe what we're proposing to do today, bearing in mind it's lunchtime, is this. So instead of offering you one main course, what we've got in store is a number of smaller dishes. So you might say that this is the tapas approach to webinar delivery that we're proposing. I suppose the difference and the drawback from your perspective is that you can't choose which dishes you like. You have to listen to them all, and so I'm sorry about that, but I hope that you find them at least palatable. The way we're going to structure this is that I'm going to begin by exploring a handful of recent cases on Section 73 of the 1990 Town and Country Planning Act and one other matter. Brendon is then going to talk to you a bit about the Office of Environmental Protection that's due to be located here in Bristol as conceived in the Environment Bill. He'll hand back to me for some thoughts on the planning white paper, and then we'll finish with Brendon giving some thoughts on the Environmental Bill's proposals to introduce a requirement for biodiversity in planning gain consents. I was planning to spend a bit of time talking about mediation in land use regulatory disputes, but I don't think we're going to have time for that today, so that's on the list for another occasion if we're ever invited back, that is. So let me kick off then. I wanted to talk to you about a number of recent cases. There we go. So I'm hoping you can see my first slide. So there are 4 cases I wanted to mention to you, and actually all I've done with the slides is listed the names of the cases. So if you're interested, you can go away and look them up afterwards. You might like, despite what Coralie said, you might like to scribble a few notes if there's anything of particular importance that you think you'd like to record. There are 4 cases there. The first 3 concern applications under Section 73 of the 1990 Act, and the 4th raises an interesting point on the lobbying of members in planning committees. So as to the first 3, the context, as I said, is Section 73 of the 1990 Act. A quick reminder about the operation of that provision. It's often described as a mechanism for the varying of planning conditions, but that isn't actually the case. What it does in practice is offer an opportunity to developers to apply for consent to develop land without compliance with conditions subject to which a previous planning permission was granted. And that's important because the outcome in the event of a successful application is a fresh permission that sits alongside the original one. If the application is refused, then the outcome, and I suppose it might be refused because typically because the planning authority takes the view that the same conditions that were attached to the original permission ought to continue to apply. If it's refused, then there's no fresh permission issued. The original permission remains intact. So either way, the original permission remains capable of implementation following the local authority's decision. Now previously, before section 31A, which was the predecessor to section 73, before that was introduced into the 1971 Act, the only way of challenging or questioning or varying the effect of conditions on a planning permission was to appeal against the grant of planning permission itself. But that was seen as a relatively unsatisfactory route for a number of reasons. Firstly, because it was only available during the period during which an appeal might take place. There's a limitation period that applied accordingly. Secondly, because it was a relatively expensive and long-winded process, of course. And thirdly, perhaps most important of all, it entailed a risk of losing the benefit of the planning consent entirely, because of course an appeal put the principle of planning permission itself up for grabs. Well, the advantage of section 73 is it contains no such risk. It's quick, it's relatively cheap. There's no limitation period, and also importantly, a decision maker can take into account the up-to-date policy and other material consideration context, including changes that might have occurred in that context since the grant of the original permission. Note briefly the contrast by comparison with section 96A and the provision the power that provides for, which of course is the power to make non-material amendments to a planning permission, including the conditions attached to the permission, the result of which, by contrast, is a variation of the original permission. So different outcome to that arises under section 73, and that's an important point. And it's the point that arises actually it provides the context for the three cases that I was going to mention. And the first of those is the Finney and Carmarthenshire case, which actually was decided now some time ago, almost a year ago. It was a case involving wind turbine development. The maximum height of the permitted turbine was specified in the description of the development, and the conditions attached listed a series of plan numbers, including one which showed the turbine or the turbine in question at a specific height. And the developer wanted to increase the height of the permitted turbine, and an application was made to do that by amending the condition that listed the relevant plans so that it referred to a different plan showing a taller turbine, and at the same time sought the deletion of the maximum height reference in the description of development. Now, unsurprisingly, it was held by the Court of Appeal that you can't use section 73 to alter the description of development in the original planning permission, or to include a condition that has that effect. And what that means, I suppose, in practice for developers and planning authorities who wish to retain flexibility in a project is that the prudent course is to define the scope of development by reference to the condition drawings, and at the same time to ensure that the description of development, the operational part of the permission, is expressed in the most general terms possible. So that was followed by Lambeth and the Secretary of State, which was a Supreme Court decision made towards the end of the summer this year. It's a slightly controversial decision made by the Supreme Court, led by Lord Carnwath, who, as some of you will know, is a lawyer with a huge amount of experience in the planning system. Nonetheless, made a decision that I think took the industry by surprise in some respects. It was a decision that concerned the implications of a Section 73 consent that related to a home-based store that failed to impose a series of both contentious and non-contentious conditions that were attached to the original planning permission, governing importantly, the range of goods that were permitted to be sold and also some other matters. Now, the court's view was that despite the terms of Section 73, and despite a pretty strongly worded judgments by the High Court and the Court of Appeal to the contrary, the Section 73 consent in this case could still be subject to the original conditions, even where those weren't included in the Section 73 consent, because the wording of the application and the description of development indicated that that was the case. And Lord Calmer said that the proper approach to interpretation of a consent in this kind of case is to find the normal and natural meaning of the words used in their context using common sense. In this case, the operational part of the permission, the Section 73 permission, was expressed in terms of a variation of condition, can't remember what number the condition was, condition X, and it was followed by the original wording of that condition, and then the wording that was proposed to be substituted. And the court said that on the facts, it was clear that this was intended to be a variation of the condition in question, and that that's how it should be treated. Now, it's a tricky decision, that, because in the eyes of many people, it stretched the interpretation of that Section 73 consent to achieve a result that was contrary to what was definitely the settled view in the industry, which is that if a planning authority wants to grant Section 73 subject to the conditions to which the original planning permission was subject, then it must do that by attaching them specifically. It was, it's fair to say, an unconventionally, and you might even say badly worded planning permission. So the facts are unlikely to be repeated. But a point of more general application was Lord Carnworth's view that even those conditions in the original permission that went entirely unmentioned in the Section 73 consent would continue to take effect, because the Section 73 consent contained nothing inconsistent with that continuing operation. And that is a proposition that appears inconsistent with the statutory scheme that we're all familiar with, that produces a standalone consent. All of which, I think it must be said, raises the prospects of similar arguments being raised about old conditions on old permissions applying to new Section 73 permissions, especially where the terms of the Section 73 permissions aren't abundantly clear. And the prospect, he says with some trepidation, of lawyers trawling through historic planning permissions on complex sites to identify what the various early conditions were and to what extent they might continue to apply, and the answers, frankly, not being particularly conclusive. I suppose it also means that for the purposes of future grants of planning permissions and Section 73 consent, all parties, developers and authorities, will be well advised to be very clear about what conditions they intend to apply to the permission, and to make sure that that's set out entirely unambiguously within the terms of the permission. Now, the third case that I wanted to mention is the Norfolk Homes case. There's another decision by Mr. Justice Holgate, raised another issue in the context of Section 73, much more recently, but this time in the context of the status of a Section 106 obligation. Now, this concerned a large resi scheme for which planning permission was granted in 2012, following the execution of a Section 106 agreement that provided for 45% affordable housing contribution. Now, in 2013 and 15, further permissions were granted under Section 73 to reflect relatively unimportant matters, different approach to construction details and some other stuff. Neither of those, importantly, were made contingent on the execution of a further Section 106 agreement concerning affordable housing. Now, Norfolk argued that the 106 should be interpreted, or that additional words should be implied into it, so that it applied to any subsequent permissions, including Section 73 permissions, and they relied in part on support from the Lambeth case that I mentioned a few minutes ago in advancing that argument. Now, the court rejected that proposition and made a number of comments. Firstly, Mr. Justice Holgate said that it was important that public documents are construed on their face without extrinsic evidence, according to usual principles. That's something that, with which we're all very familiar. And I should say in passing that I was struck by the, I was reading this just the other day, I was struck by the repeated references in the decision to the 2016 decision in the Trump International Golf Club and Scottish Ministers case, which, given recent events, I have to admit, put a wry smile on my face and a warm glow in my heart, which I have to say is unusual when reading a judgment of Mr. Justice Holgate. But there we are. The second thing that the court did was to distinguish the Lambeth case on the basis that that was a case concerned with the meaning of a current planning permission rather than the interpretation of a historic document. Thirdly and fourthly, and these are the two important points really, he said that the parties could have used wording in the Section 106 agreement to apply it to subsequent planning permissions, but chose not to, clearly, and that the Section 73 consents could have been made contingent on fresh Section 106 agreements or deeds of variation to the original Section 106 agreement, but were also not done so. And he pointed out that if Norfolk was correct in its approach, then the effect of that would be that all Section 106 agreements would apply to all subsequent consents, save where the parties took the care to exclude that specifically in writing, and that would clearly be an absurd outcome. But what do we learn from all of that case and the other two that I mentioned? Well, I suppose collectively they amount to yet another reminder that Section 73 consents stand alone. And although in theory that's something we all know, we all seem to forget it from time to time. Forgetting it raises serious questions, not just for the operation of future obligations under Section 106 provisions and conditions, but also past and ongoing ones. And I'm thinking, for example, about open space requirements and the maintenance of those areas, financial contributions already paid, serious implications raised in relation to those by getting this wrong. And finally, the simple point, an obvious one, I suppose, but I'll make it anyway. There are two stages at which parties need to consider very carefully what needs to accompany planning permission and ensure that that is secured in the drafting. And those are, firstly, the original planning permission stage. And the question there will usually be whether the Section 106 agreement should be drafted so that it bites on subsequent consents or not. And usually the answer will be no, to allow flexibility, but not always. And secondly, at the Section 73 stage, what needs to be provided for in Section 106 terms and which conditions should continue to apply. So those are some thoughts on the first three cases. I wanted to mention briefly the fourth case there, the Holborn Studios case, which was a case decided by Mr. Justice Dove this summer, concerned a resi commercial scheme in Hackney. There were 2 points arising out of the decision. It's neither of these points are groundbreaking. Actually, one of them's already been discussed, I think, in reasonably widely. The second point is one of interest, which is why I mention it today. The first point concerned the tightening of the rules on the transparency of viability assessments provided in support of planning applications following the 2018 NPPF amendments in that respect. And actually, the judge quashed the decision on the basis that the council had withheld information that the public ought to have been entitled to. It was a decision that I think has alarmed developers across the country for reasons, well, for many reasons, but I suppose particularly for reasons of commercial sensitivity. But the second interesting issue that arose in this case concerned the question of the lobbying of planning committee members. This is, I think, an interesting point, if not necessarily a particularly surprising one. So Hackney had a code for councillors which prohibited members from reading lobbying material that had been provided by members of the public in relation to planning applications without subsequently declaring an interest and then withdrawing from the vote. Now, lobbying of members is something that clearly happens in practice across the country. My experience suggests that there is some widespread uncertainty as to what's actually allowed, and that in some cases this translates into a reluctance to be open about conversations that have happened, which can then have implications in terms of potential allegations of bias and so on, if they're subsequently revealed, having been sort of not disclosed. Surprisingly, it's a question where you might think it's not surprising, but I suppose on one analysis, it is surprising that it's never been tested in court. Well, in this case, Mr. Justice Dodd addressed the point directly, and he said that he said this: reading the communications from objectors to planning applications is an important feature of freedom of expression in the connection with development control decision making, and he cited the European Convention Article 10 on freedom of expression. And he said that in fact not to allow that to happen could in principle be an interference with that right, rendering a decision unlawful. That wasn't the case in this case, because the barrister for the objectors made the points that had been made in the paperwork by all representations at committee. But it seems to me to be useful because it establishes for the first time the right of, in law, albeit in common law rather than statute, the right of councillors to receive info about proposals from the public and to consider it when reaching their decisions. And to that extent, it seems to me to be a helpful statement of a sensible approach. Interestingly, he went on to say that the risk of associated with misleading or illegitimate material can be allayed by members passing that material onto their legal team, which again seems to me to amount to sound practice, although it's not clear whether in public law terms that might be a legal requirement. So I'm going to leave that for you to ponder, although the answer in reality is that probably it depends on the circumstances. So I'm going to finish just by drawing your attention to that slide, which is a visual representation of the state that you as lawyers will be in when advising your client on which conditions currently apply to its development site, before I hand over to Brendon, who's going to talk to you about the Office of Environmental Protection. Brendon.
Thank you, Harry, and also thank you to everyone for attending today from me. I'm no expert at technology. I will do my best to now put my slides up on the screen. Just to forewarn you, I was in a hearing earlier on this week with someone who was having difficulty logging into their the court attendance and ended up using his mobile telephone, and we were all treated to a close-up view of his ear whenever he was trying to listen to proceedings that were going on. So if I achieve something better than that, I'll be happy. Just bear with me one moment. Hopefully that is now visible to everyone. The theme that I wanted to talk about, because we're being asked to discuss emerging themes in environmental and planning law, is one that is hugely fundamental to the way that environmental law will be operating from January next year. It follows, as we all know, from the implementation of the decision to leave the EU. And from that point of view, as my slide says, the UK and Northern Ireland are about to set off on quite a different journey to the one that we as environmental lawyers and where it affects them, planning lawyers, are used to in relation to how we approach case law and the primary legislation. We're all no doubt familiar with the direct effect principles of the EU as set out in Van Genden-Loos and the other authorities that follow on from that. And we're all no doubt aware of the way that that has been administered within the United Kingdom, with England and then the devolved administrations having their separate responsibility for implementing those directives, regulations, and any other relevant law. Obviously, we have seen, as we have across Europe, even within the UK, quite different methods of implementation, or sometimes slight differences in implementation. And the classic examples of that, which those of us who are in the West Country are inclined to encounter, are those variations between Welsh legislation, things like the Wellbeing of Future Generations Act 2015, or the Welsh Environment Act 2015 for that matter. More fundamentally, as far as the implementation of laws and the application of laws, has been the way that those laws have been effectively overseen. And again, people may be aware that there were various routes by which, if domestic law didn't bring about the proper implementation as the party sees it of European law, that application could be made to the European Court of Justice, or in some cases matters could be raised by way of a complaint to the EU Commission. And a good example of that, relatively recently, it's still subject to the statutory instruments being implemented, is, for example, a complaint brought by the Welsh Rivers Trust against Wales or the Welsh Assembly Government for the non-implementation of the effectively the nitrate vulnerable zone scheme that operates within England, which complaint triggered an undertaking to bring about legislative change, which in turn has turned into statutory instruments, which I think there is some discussion about their effectiveness at this stage, but it triggered that response. And that is one of the methods that was used by people to bring about uniformity across the EU. Post the transition period, which of course we all know ends at the end of December of this year, effectively where we are at the moment is during the transition period, all EU laws remain effective, and any changes that are adopted, and it seems changes in legal interpretation of those regulations and directives, will be applicable up until the 31st of December. There was a period of time when the EU Withdrawal Act was originally passed prior to its amendment, where the UK was going to be subject to a transition period where we followed European law and the changes in it, and then reverted back to the position in January. But they've amended that situation so that come the end of this month, December, the end of the year, the law effectively will be fixed, subject to any UK domestic changes after that date. So all EU law as of the 31st of December remains, unless it's changed. So there's no change so far as things regularly used, legislation and statutory instruments that implement directives, environmental permitting regulations effectively will remain. Town and Country Planning Act will remain. There have been, as people will again have noted, amending statutory instruments which simply amend the relevant wording so that it's not, there isn't recourse to European oversight. But the most critical thing is that direct oversight by the Commission and the European Court of Justice ceases. What will replace that? Interestingly, there will be, it seems, because of the timing of the position that we're in, there'll be, it seems, a gap immediately at the end of the year, because the Office of Environmental Protection and the Environment Bill, as it is now, is not believed to be able to come into force immediately. So there'll be a period of time where there will seemingly be no oversight from the Office of Environmental Protection. There, of course, will be oversight from the courts and the continued ability to bring actions based upon the existing legislation before the court. But what will replace that oversight mechanism, and this is a fundamental change, is the Office of Environmental Protection, based locally in Bristol. And it's believed that the head of it, although it's, I think, just open for application in August, it's believed the head might be Sir Richard McCrory, who is understood effectively to be running a shadow organisation at the moment, based in Bristol, effectively shadowing the Commission's role and trying to work its way into the potential problems that it would have to deal with. What will the OEP do? Well, DEFRA describes it as being a powerful new independent regulator, and its role effectively will to replace the Commission's oversight role so far as environmental compliance. As my slide says, health warning, obviously this is a bill at the moment, and the proposals are clearly able to be changed, although what follows has been fairly well settled for some time, and I don't think there'll be any significant changes from what I can see. So the OEP will have a role to determine if there have been serious failures to environmental law, and they will have a set of enforcement functions. They replicate the Commission's role in that they will have the responsibility of trying to ensure that environmental targets are set, and the Environment Bill sets out priority areas, air quality, water, biodiversity, and resource and waste management and waste reduction. Anyone looking at the legislation who is used to dealing with environmental regulation will be perhaps somewhat put out to see that the legal requirements in the bill are for the government to select one indicator of each of those priority areas and set targets, measurable targets in relation to each of those indicators, which if one just considers the question of air quality alone, if they apply the minimum statutory requirements, we could see changes potentially in monitoring of things like nitrous oxide in air, sulfur emissions, particulate matter. We could very readily, those of us who work in the field, probably rattle off half a dozen, if not many more, key indicators of each priority area, let alone one. One hopes that the government will consider a broad spectrum of the relevant areas from an environmental protection point of view, but there's at the moment, no legal requirement for them to go beyond the one indicator for each of those 4 areas. Going back to the OEP's role, they, as the Commission will be able to receive complaints, and the complaints have to be in relation to the activities of a public authority, and that a public authority has failed to comply with the environmental law. And of course, that could apply from anything from central government, planning authorities, local authorities in their other statutory duties. I suppose the Environment Agency, all sorts of bodies could fall within the subject or the remit of having complaints made about. And the OEP will have to consider those complaints as the Commission did. A criticism of the Commission was that they appeared fairly arbitrary in the way that they approached their dealing with such complaints, and there wasn't a ready way of challenging a failure by them to act. And similarly, at the moment, I've yet to see any mechanism for triggering the OEP to act in a particular case. I imagine that judicial review proceedings may prove very difficult given a wide discretion and a lack of a framework, a published framework as to how they approach things, but that may be a situation that changes. But essentially any public authority now will potentially come under scrutiny of the OEP, and the OEP will follow, if it believes that there is a serious failure in relation to environmental law, follow what is a completely new enforcement regime within the UK. The enforcement system seems to follow a system of notices that runs parallel to the powers given to the Financial Conduct Authority. And it may well be that as people consider the effect of this legislation and the legality of notices or arguments about matters of that nature, that there will be recourse possibly to the analogous cases that come from the Financial Conduct Authority. Again, completely new area of law. And again, that is very speculative on my part as to how it will be approached. But they seem to be modeling the system that, as I say, has been tried and tested in the financial world. So what can the OEP do? Well, they will follow a series of steps. The first thing they can do is serve on a public authority an information notice which sets out the alleged breach. That notice will require a response by that relevant authority, and the notice may include steps to be taken to remediate or remedy the situation. It's not difficult to imagine, for example, when one looks at the Client Earth litigation in relation to the Secretary of State and the Air Quality Directive, it's not difficult to imagine that in particular agglomerations, Bristol or big cities where there are known air quality problems, that subject to the criteria still applying, and I've mentioned what the government's targets will be, but subject to those targets still applying, that effectively local authorities who the Secretary of State effectively devolved responsibility for the clean air targeting, could find themselves subject to enforcement notices or information notices, complaint by the OEP, if remedies don't take place. That's an example of how I can see, or an early trigger, given recent litigation, as in the last 4 or 5 years, recent litigation, where this may bite fairly quickly. The next step after an information notice, and there's a timetable associated with that, I haven't set it all out here because obviously things like timetables and the like may be subject to change, is that if that doesn't satisfactorily resolve the situation, the OEP can issue what is called a decision notice. That's only if the information notice has been served. And effectively that is a final warning, a compulsion to act, and essentially if the decision notice isn't complied with, the OEP can then start formal legal proceedings, which start with an application to the upper tribunal for an environmental review, and the upper tribunal the Environment Tribunal can issue a statement of non-compliance, and they have powers, or will be given powers in accordance with the bill for judicial review remedies other than the award of costs or damages. Sorry, damages, not costs. Other than the award of damages. And so essentially where the upper tribunal will leave a relevant public to a legal compulsion to act, and failing a legal compulsion to act under the upper tribunal's orders, which clearly could have its own consequences if it has full judicial review remedies, the OEP can apply for a judicial review to prevent serious damage. So quite a different framework to effectively where we sit at the moment, which would be a complaint to the Commission. If the Commission upheld that complaint, they could fine the relevant nation state. This is far more targeted towards the public bodies who have responsibility for acting in those particular cases. And obviously it remains to be seen how that is implemented by the OEP, what approach they take towards it. And it's no doubt going to lead to a whole new species within the UK of environmental enforcement and potentially litigation as that process adjusts itself to the new world order that we now live in. There will, of course, be the complexities for all environmental lawyers and people dealing with environmental regulation, that there is going to be the complexity of trying to apply European legislation as of the 31st of December with ad hoc variations within the UK legislative regime, which won't necessarily follow, because of the difference in approach, won't necessarily follow the approach taken by the European Parliament and the Commission and the European Union in the way it has legislated. And I'm sure that there's going to be quite a lot of, again, bedding down and legislation in relation to what approach should be taken to the hybrid legislation as it evolves over the next period of time. And I conclude with that headline emerging theme. The so far as the environment is concerned, there's going to be, excuse me, I'll try and go back. As far as the environment is concerned, there's going to be a huge change in the mechanism of oversight that we are going to be subject to as a country, and also the people that are going to be enforced against by this OEP, or let's say the people, the legal people, the organisations and public bodies, as opposed to nation states or likewise. So apologies, I've given you a sneak preview of the next slide, and I shall try and stop sharing my slide now, if I can, or if Harry can maybe intervene with his slide. That might be an easier way of doing it. But thank you.
Yeah, thanks, Brendon, for that very interesting discussion. I'm going to talk briefly, if I may, about the planning white paper. Now, look, this is something that has been planning for the future, is a consultation paper to reform the planning system that's been subject to consultation over the course of the summer, as you know. The details have been explored at great length over the course of the summer in numerous webinars and articles by most of the planning industry. And the consultation period is now ended. So I suspect there's limited appetite to engage in an analysis of the various individual proposals in detail at this stage. So I'm not going to do that, but what I am going to do is to share one general insight with you, if I may. And it concerns what I perceive to be a conflict between the manner in which the white paper is described by government and what it actually does. And so I suppose in some senses I'm alleging a kind of misrepresentation or mis-selling of the paper. Because if you stand back and look at the white paper, it seems to me that two central themes running through it emerge. Now, the first of those is what I would describe as a sort of re-engaging with the public. And I think that's evident from the following extracts of the paper. These are all either direct or almost direct quotes. The aim, we're told, is to rebuild public trust in the system. This involves reconnecting with communities. It's to be achieved by, among other things, inviting residents to become more engaged and have a greater say over what gets built. The suggestion is that we will see the introduction of genuine community involvement, all of which means, and I think this is a really important bit, local democracy and accountability will be enhanced. That's the first central theme that I see running through the paper, and I think it's pretty plain from that what is intended on the face of it. Now, the second theme that I spot is essentially concerned with what I would describe as the need to deliver development and more of it quicker. And the examples of the way in which that is expressed are as follows: making decision-making faster and more certain, streamlining the opportunity for consultation, and my euphemism alarm sounded loud and clear when it read those words, streamlining the opportunity for consultation at the planning application stage, because that adds delay to the process, all of which is part and parcel of the objective of increasing the supply of land for new homes and building the homes that our country needs. Now, I have no problem, and I make no comment about the merits of either central theme. It seems to me that both are important, reasonable, and entirely deliverable. But I have a reservation, which is based on experience, which in my case suggests, I think, that to some extent at least, those two themes are mutually exclusive. Because the reality, I think, is that most of the public is largely hostile to development in most cases, and sure, for entirely predictable and normal reasons: fear of change, hostility to strangers, concern about land values, increasing pressure on infrastructure, environmental concerns, and so on. All very normal reactions to development proposals. But my instinct is that what that means is that the more influence you give the public over development control, the less development there will be. And if you look carefully at the substance of the white paper, as opposed to the spin, if I can put it in those terms, I think actually the government also recognises that. Because the net effect, it seems to me, of the proposals will not be to increase public involvement or democratic accountability, but to reduce both of those. And there's a particular sentence, I think, that gives that game away. And that reads as follows: planning decisions are discretionary rather than rules-based. This is a criticism of the existing system. Planning decisions are discretionary rather than rules-based. Nearly all decisions to grant consent are done on a case-by-case basis rather than determined by clear rules for what can and can't be done. So the government is criticising the discretionary case-by-case approach of the current system. It seems to me absolutely true that the effect of these proposals will be to limit that discretion of councils and the public opportunity to influence the way that's exercised, and to centralise power so that decisions aren't taken on a case-by-case basis in quite the same way. And just look at the list of measures proposed. For example, zoning, to grant automatic outline planning permission in growth areas, or to confer a presumption in favour in renewal areas. The taking the discretion, the jurisdiction for the setting of housing targets away from planning committees and handing that responsibility to Whitehall, from where those targets will be imposed in a to coin a phrase, a top-down way in binding terms, removing the power of planning authorities to negotiate their own Section 106 agreements, expanding the categories of delegated decisions at the expense of committee decisions, particularly in relation to matters of detail, limiting the right to public consultation on certain proposals, again at the detailed stage of two-phase application processes. And I think this is particularly interesting: awarding successful appellants planning fee refunds, and thus, to my mind at least, threatening implicitly under-resourced. Well, actually, it's not an implicit threat, is it? It's an explicit threat, threatening under-resourced authorities with a disincentive to refuse marginal schemes. That's what's proposed in practice. Apparently, balancing that, offering compensation for what some people might describe as a democratic deficit, is a commitment to, quote, move democracy forward, which is clearly a reference to the plan-making process. This is all about front-loading the system by consulting in greater detail at an early stage of the process, and digital innovation, for example, by making access to local plan consultation easier, including, quote, whilst on the go on a smartphone, whatever that means in practice. And my concern is this, really, that the public tends to view the planning system as relatively uninteresting. The exception, of course, is when we're faced with the immediate prospect of unwelcome development in our own backyards. But in terms of the planning system as a whole, it's my experience that the plan-making system in particular is uninviting to the public. I think it's often perceived as a long and complex process concerning the distant prospect of change, and one which requires a capacity to navigate vast amounts of paperwork, something for which it seems to me that a smartphone would be entirely unsuitable. But that's just not my view. And so I wonder whether it really is realistic to expect the public to engage in it in significant numbers. I have my doubts, frankly. My expectation is that the public will continue to approach the planning system in the way that they have always done, namely by ignoring it until some nasty developer comes along and forces engagement by proposing an incinerator in the school playground or whatever it happens to be, by which time, in most cases, under the arrangements proposed by the new system, it will be too late. And so I think the net effect of these proposals will be that the public feels overall more excluded than included, and that democratic accountability will be reduced accordingly. Now, I suppose in the government's defence, the planning system faces a near impossible challenge. That challenge is about striking a balance, isn't it, between protecting the rights of communities to influence the development that takes place in their areas, and at the same time delivering the development that's economically and socially essential. And on this small and crowded island where property is almost a national obsession, it seems to me that conflict is not far off unresolvable. That doesn't mean, of course, that this government, like almost all previous ones shouldn't attempt it by the latest in what is undoubtedly the latest in a long line of reforms described as fundamental or radical. That's a concept with which we're all very familiar by now. But my sense overall is that instead of adjusting the balance in favour of public involvement, or even maintaining that status quo between those two competing interests, this paper sets out to achieve the opposite. Now, without expressing a view on the merits of that, that's not what I'm here to do, it does strike me that that isn't what the white paper claims to do. Before I finish, is a slide of showing a photograph of a bunch of young people enjoying themselves, engaging in local plan consultation whilst on a smartphone on the go. And whilst you enjoy that, the final thing I wanted to do was on the subject of subsequent fundamental and frequent reform. I'd like to end by quoting a couple of short extracts from the personal consultation response to the white paper of Lord Carnwath, whose name's cropped up a number of times in this discussion already, which he submitted a couple of weeks ago, which I stumbled across. The man who has more experience of planning than most of us in this virtual room, probably than most in the country, and almost certainly more than anybody in government. I think his thoughts are interesting, and I thought you might be amused to hear them. It's only a couple of sentences, so I'll read them through. And I should say that these are extracts from a much longer response, but these are the sentences that struck me as being of particular interest. He says, "My simple advice to government now is not to repeat the mistakes of the past. In my experience of 50 years, the planning system is soundly based and in general has served us well, but has not been assisted by frequent changes of policy direction. Radical reform," he says, "is rarely a sensible solution, not least because of the disruption it causes. The white paper does not begin to make a case for it in the present context." So there we are. I thought that was a set of propositions that was difficult to argue with, and a nice note on which to end. And so I'm going to hand back. We've got 5 minutes or so to go, I think, back to Brendon to give you a quick rattle through on proposals in relation to biodiversity gain in the Environment Bill. Brendon.
Thank you, Harry. I'm just sorting out my visuals here. Does everyone have that now on their screen? So I was just going to talk for a few moments about one of the other changes that is taking place. I focused on the proposals, which again are within the Environment Act, to do with implementing, or which are proposing an implementation of a deemed planning condition, or in fact 2 planning conditions in all future planning consents. And that theme of looking after biodiversity and biodiversity loss is something which isn't new, but it appears to be crystallizing into sets of regulations which are a lot more structured than they have been in the past. We all know that the amendments to the National Planning Policy Framework, I think, introduced another 27 references to biodiversity. I think it went from 3 to over 30 references to increasing biodiversity. But this legislation appears to be more aimed at crystallizing actual tangible and measurable changes. The underlying drive is that, according to the Joint Nature Conservation Committee, there's been a significant reduction in biodiversity within the UK. You can see on the chart that I've got up there, starting with an index of 100 back in 1970, we're now down to about 40% of that in relation to priority species within the UK. And so a measurable long-term and seemingly ongoing decline in biodiversity within the country. The Environment Bill seems to be trying to grapple with those difficulties, which don't appear to have been arrested by previous efforts to reduce the destruction of biodiversity within the UK. And so clauses 90 to 99 of the Environment Bill deal with biodiversity gain in planning, and it also deals with the biodiversity objective and reporting, and also local nature recovery strategies. The amendments that are proposed also include amendments to the National Environment and Rural Communities Act in 2006. And in general terms, what we are likely to see is a small change in wording, but perhaps a significant change if it is tested in court. There is going to be the imposition of a general biodiversity objective of conservation and enhancement of biodiversity in England, and a duty for public bodies to not just conserve, which is the previous wording, but to conserve and enhance biodiversity in the decisions that are reached. And so there is also going to be an obligation on local authorities to prepare plans and to take action, and also to report on progress towards achieving the general biodiversity objective. And of course, some of the people present in this, listening to this talk, will be aware that there's a requirement for preparation of local nature recovery strategies. In part, this is going to be implemented, and certainly in a planning context, by adding a new schedule to the Town and Country Planning Act, Schedule 7A. And the wording of that can be found in Schedule, if anyone wants to look at it, Schedule 14 of the current Environment Bill. Schedule 7A will require a consideration of the biodiversity net gain of a development, with a requirement to achieve a 10% net gain of biodiversity on or near the development. The percentage gain will be measured against something called the biodiversity metric, which is something which DEFRA has already published. The first version of it, and it's been amended for some time, was originally introduced in 2012 as effectively a testing process to see how it worked. The current version, Biodiversity Metric 2, seems to be very close to that which would be actually implemented. And the proposals are that it'll be phased in over a 2-year period. So what does Schedule 7A impose so far as planning law is concerned? Well, it imposes a general condition which applies to every planning permission for development that's granted. And I'll read it. Every planning permission granted for the development of land in England shall be deemed to have been granted subject to the conditions in subparagraph 2. And those are: the condition is that the development may not begin until a biodiversity gain plan has been submitted to the planning authority, and the planning authority has approved that plan. Notably, as far as the bill is concerned, the provisions currently seem to apply to every development, whatever its scale or location. There have been pilot areas where they've looked at many different versions of that. And my assessment is that when it's practically implemented, that there are likely to be exemptions, such as for permitted development, domestic household extensions, things that wouldn't normally have a significant change to the biodiversity of an area. There may also be exemptions for brownfield sites, and there may also be a simplified structure for small-scale developments. And an example of that, I think, is deemed to be housing developments under 20 houses, but obviously the final details of those may be subject to change. The legislation also provides for the purchase of credits or offsets to meet those biodiversity objectives, which essentially replicates age-old planning propositions or concepts, such as the mitigation or compensation for developments, and possibly also looking at things like carbon trading and waste packaging, where you can buy offsets effectively for carbon or waste. So those aren't new concepts, and they are likely to be applied in this case and in relation to this legislation, because of course not every area you'll be able to provide for an immediate biodiversity gain linked to any development. There's also likely to be a 30-year maintenance requirement in relation to obligations. The current areas where they've piloted this, I think most of them, if not all, have required in perpetuity requirements, which has caused some people headaches as to how that in practice could work out. So I think the maintenance requirements for any biodiversity gain is going to be limited to about 30 years. And of course, all of this puts quite a lot of additional burden on local authorities, because in relation to planning applications, now there are these further steps that will need to be considered and further documentation that will need to be reviewed, and of course a significant burden to developers who will need to understand these regulations and understand when they need to look at getting relevant evidence for biodiversity gain and when not. The areas that may give rise to contention or difficulty, and these come from the pilot areas and also basic general principles, it's believed that any biodiversity loss will be required to be offset or enhanced in as close as possible areas as is reasonable to the development. And of course, that will be something which is of an intangible nature. It'll depend on the nature and scale and location of the development and any sensitivities in that area. And of course, anything like that renders decisions in relation to that subject to challenge. Also, there will be potential difficulties with specific developments that have usually given rise to objection, intensive farming, for example, incinerators and the like. And it'll give another string to objectors' bows, or to the determining, or to the bodies having to determine the issue, another factor to consider. And those factors may be quite, they may not be limited to the effects in the local area. For example, we are no doubt all aware of issues that can arise from intensive farming and effects on water quality nearby, where not nearby, many miles away, and really the effect of whether or not harm is in fact being created by these areas or will be created by these areas. Another area of challenge so far as these were raised by this biodiversity test. Pilot areas have also had difficulty in identifying suitable offset sites, so a limit in or a brake potentially being put on development if you can't find suitable offset sites to compensate or mitigate or provide compensation for what you're doing in a particular location. It may cause difficulties. And local planners have encountered severe difficulties financially. The financial implications of implementing this, many thousands of pounds. DEFRA, you'll be pleased to know, anyone who works for a local authority has promised financial support, and we wait to see how the extent of that will be followed through. So that's something which is heading through the pipeline. It's moving from, as I said, from general propositions in things like the National Planning Policy Framework, general propositions in decision making, to quite specific biodiversity assessments with what ought to be measurable and tangible requirements, and a requirement to increase by 10% on applications biodiversity in linked to a specific proposal, 10% biodiversity increase in that area if at all possible. And of course, when one considers the background driver behind this, which is that steady decline, that chart showing the steady decline in biodiversity, one can foresee that once the government has a framework by which they can set measurable objectives, then it becomes a lot easier to fine-tune that and to increase it if required or not. So this may well become quite an increasingly significant factor in decision making, depending on how well the current proposals, how effective they are at stopping the decline in biodiversity. So, as I say, the headline, the new section, Schedule 7A of Town and Country Planning Act, will introduce quantifiable biodiversity assessments, and the requirement for enhancement will soon be a requirement in a great many developments that we are coming across on a day-to-day basis. Thank you. I don't know that's all certainly so far as our contributions. I think our tapas was concerned, and my own personal thanks to everyone for staying and listening. And
so there are a couple of questions that have been asked, which Brendon and I would be delighted to answer quickly before everybody gets fed up and wants to go get on with their afternoons. So the first question was a question from Hayley Jules, who asks about deeds of modification in relation to Section 106 agreements. And this is something that arises out of my talk at the beginning of the session about the effect of Section 73 and related matters. And she says, if a Section 73 varies a condition on a permission that's subject to a Section 106, then a deed of modification is required. So a clause could be written into the original Section 106 to say that the Section 106 applies to the original permission and to any subsequent Section 73 application to save a deed of modification each time. Is that right? And Hayley, I think the answer is that is right, and that is what Mr. Justice Holgate said in the Norfolk case hadn't happened. And had it happened, then the affordable housing requirement would have continued to apply to the subsequent consents, and it would have saved everybody a whole lot of bother. Of course, it won't always be appropriate, is the answer. There might be reasons why an authority might want to confine the effect of a Section 106 to a particular planning permission. It might be because they envisage, or it is envisaged, that evolutions in the scheme might take place over time. It might be because they want to protect themselves against changes in material considerations, whether that's changes in policy terms or other material considerations. And so for that reason, it won't always be the right thing to do. And in practice, it isn't particularly common. And I think that is the reason why authorities are keen to preserve flexibility. And so in many cases, the preferred approach is simply to revisit the matter at the Section 73 stage, and that can involve a deed of variation or a fresh Section 106 as appropriate. So I hope that's a helpful answer. There was a question that was asked in the run up to in advance of the session today. I'm not sure who asked the question, but it was a good question that raises the question about the implementation of wildlife legislation under the new planning proposals. And the question was, how will that be done? And I'm not sure quite which legislation the questioner had in mind, but I think there's a two-part answer to the question. The first part is to say that the question raises a really important point about how a front-loaded planning system will deal with a whole range of specific impacts that can't be fully assessed in the absence of detailed proposals. And those impacts arise in the context not just of wildlife protection, but all sorts of other issues too. And transport, for example, is another one that seems to me to have the capacity to cause problems in that respect. I think the second part of the answer is that there are proposals to simplify the EIA process that are also part of the white paper measures. And that, it seems to me, also raises questions about the adequacy of the scrutiny of proposals in terms of matters like wildlife proposals. And there's no doubt about it, the EIA process is a cumbersome one, generates huge amounts of paperwork and cost and time, and absorbs time, but that it might be said, is inevitable given the complexity and the importance of the subject that it deals with. And so a loss of rigor in that area going forward would be regrettable. So I suppose that's a sort of long-winded way of saying that I don't know the answer to the question, but like the person who asks it, I and I think many others have concerns about the way in which these detailed impacts of development proposals are going to be handled under a planning system that will work in a very different way. Were there any other questions? I've got none on my Q&A function. I don't know if Coralie, you're still there. Are you still there in the background?
Yes. Can I just add for my part? I think there was another question someone asked again prior to coming today about practice in environmental and planning work at the bar, and of course there may be other questions that people have had arising from this that follow up. Please do get in touch. Harry and I would be very happy to try and answer those questions. It may not be a sort of general application to everyone to know what it's like to work in an environmental planning bar, but whoever it was who asked that question, if you're here, please do email us, find us on the website, and get in touch. And likewise, if there are issues arising from anything that we've said, then again, we're not the old stuffy bar. Please do get in touch with us, and we'll do our best to assist.
Yeah, I'd echo that. Thanks, Brendon. It's been a pleasure to talk to you all, and I wish you all a very pleasant afternoon.
Thank you both. I'd just like to thank you on behalf of Bristol Law Society, both Harry and Brendon, for taking the time to talk to us today. And as I mentioned at the start, we will be circulating details after the event, so you should get an email from us at some point in that. And thank you very much, everyone. Goodbye.